Okay, I'm going to finish up speech here with commercial speech, campaign spending, and then we're going to go into freedom of assembly, which is still the First Amendment, and right to associate, First Amendment, part of assembly. Okay, so we've talked about First Amendment when it comes to symbolic speech, libel and slander, obscenity, prior restraint, which is censorship. And now let's talk about business speech or commercial speech. As we have seen, not all forms of communication receive the full protection of the First Amendment. Laws restrict commercial speech, such as advertising, far more extensively than expressions of opinion on religious, political, or other matters. The Federal Trade Commission decides what kind of goods may be advertised on radio and television and regulates the content of such advertising. These regulations have responded to changes in social mores and priorities. At one time, for example, tampons could not be advertised on TV, but cigarettes could. Today, the situation is the reverse. The FTC attempts to ensure that advertisers do not make false claims for their products, but truth in advertising does not prevent misleading promises. For example, when ads imply that the right mouthwash or deodorant will improve one's love life, think of like Axe, cologne. That dubious message is perfectly legal. It's considered puffery. And sometimes you might actually have to look at the fine print, not FDA approved or whatever. One example from a few years ago where the FDA did go after someone was KFC, implying, well, someone held a bucket of fried chicken, literally a bucket, that chicken was healthy, and that ad was a little too misleading. So anyway, nevertheless, laws may regulate commercial speech on the airwaves in ways that would clearly be impossible in the political or religious realm. Political and religious speech is the most protected. Laws may actually require manufacturers to include certain words in their advertising. For example, the makers of Excedrin pain reliever were required to add to their commercials the words "on pain other than headache." The claim of superior effectiveness was based on tests of how Excedrin relieved pain that many women experience after giving birth. I don't know what they're referring to, but think of also all the prescription drugs, and you hear all the side effects at the end. That's required by law. There used to be a time though when they were not even allowed to legally put commercials for prescription drugs. Although commercial speech is regulated more rigidly than other types of speech, the courts have been broadening its protection under the Constitution. Remember, someone sues and we learn something new. For years, many states had laws that prohibited advertising for professional services, such as legal and engineering services, and for certain products ranging from eyeglasses and prescription drugs to condoms and abortions. Advocates of these laws claim that they were designed to protect consumers against misleading claims, while critics charge that the laws prevented price competition. The courts have struck down many such restrictions, including restrictions on advertising casino gambling, where such gambling is legal, as violation of freedom of speech. In general, the Supreme Court has allowed the regulation of commercial speech when the speech concerns unlawful activity or is misleading, but otherwise, regulations must advance a substantial government interest and be no more extensive than necessary to serve that interest. So you have to prove the government. It's all about the government here. It's not about like a private TV channel choosing not to run something. If the government's going to make rules, it has to put a direct connection that it's necessary and that it doesn't go beyond what is absolutely needed. And of course, how do we know that? Lawsuits. Somebody sues, somebody complains. You go from there, and then the courts decide. The FCC regulates the content, nature, and very existence of radio and television broadcasting. Although newspapers do not need licenses, radio and television stations do. A licensed station must comply with regulations, including a requirement that it devote a certain percentage of broadcast time to public service, news, children's programming, political candidates or views other than those its owners support. Now, here the rules are more relaxed for cable channels, which can specialize in a particular type of broadcasting because consumers pay for and thus have more choice about the service. It's interesting about the cable one, though, is because they do bundles, and people arguing that they shouldn't have to pay for one channel just because they want a set of channels, but they don't want to pay for that channel. So that can be frustrating, but that's private business. The FCC regulates if you have an antenna and you can get that channel for free through the antenna, same with radio station, that's what's falling under FCC. So that would be ABC, NBC, the locals, ABC, NBC, CBS, and Fox, not Fox News, but WXMI. Because they cross airwaves, they regulate those airwaves so they're not crowding each other out, and it crosses state borders, and therefore is a commerce enumerated power. Licensing would clearly violate the First Amendment if it were imposed on the print media. For example, Florida passed a law requiring newspapers in the state to provide space for political candidates to reply to newspaper criticisms. In Miami Herald v. Tornillo, 74, the court, without hesitation, voided this law. In contrast, in Red Line Broadcasting Company v. FCC, the court upheld similar restrictions on radio and television stations, reasoning that such laws were justified because only a limited number of broadcast frequencies were available. So they're arguing anybody can do a newspaper. So you make your own newspaper if you want to counter newspapers' criticisms. But you have to get a license, and it's limited because the airwaves are limited for television and radio. Of course, we're not talking about cable channels. One FCC rule regulating the content of programs restricts the use of obscene words. Comedian George Carlin, you should look him up. He's well known by people my age, had a famous routine about words that could never be said over the airwaves. A New York City radio station tested the FCC rule by airing his routine. The ensuing events proved Carlin right. In 1978, the court upheld the commission's policy of barring obscene words from radio or television when children might hear them. Similarly, the FCC twice fined New York radio personality Stern $600,000 for indecency. Had Stern's commentaries been carried by cable or satellite, which they do now because he's on Sirius XM, instead of the airwaves, he could have expressed himself with impunity without punishment because cable is viewed as private communication between individuals. Another case was when, what if you're hosting a live event at like the Oscars and the person receiving the award uses the F word, and then the FCC fined the broadcaster, CBS or whoever it was, and there was a big legal argument about swearing and who's responsible. If is the company responsible, the TV channel responsible if somebody else beyond their control swears. I think they ruled yes, they are still responsible, but it's been about 10 years. I'm not quite sure I remember. It was about Bono from U2 and maybe even Cher. The Supreme Court has held that government has a legitimate right to regulate sexually oriented programming on cable television, but that any regulation designed to do that must be narrowly tailored to serve a compelling government interest in the least restrictive way. In 1996, Congress passed a law banning transmission of such programming for most of the day, so that children would not be exposed to it. The court concluded that targeted blocking, which allows subscribers to ask their cable companies to block specific channels, is less restrictive and feasible, an effective means of furthering the government's compelling interest. So banning transmission could not be justified. So now that if you have an opportunity with cable companies to buy a family package, you can't, the government, that is the least restrictive way of handling children seeing bad stuff on TV. So cable companies are, again, private businesses in a relationship You pay for it. It's not through the airwaves. Okay, next one, campaign spending. Oh, and by the way, what they don't talk about here too is things like billboards, time, place, manner. Billboards restricted on like how big they can be, how many signs you can have in front of your party store, uh, the how tall the McDonald's sign can be. Gaines Township over by East Kentwood, all the signs on that exit are low. They're not large signs because Gaines Township has a restriction on how tall signs can be. There's a billboard restriction on the buildings in downtown Grand Rapids. They've grandfathered in a couple that are there, but you'll notice it's not full of billboards on, tacked onto a building. Um, the billboard companies though can restrict. They can choose what they advertise because they're private businesses. But the government can restrict. Local governments especially can restrict where they are, time, place, manner, and how they do it. Another one example would be the car companies that use too many balloons and whirly things near the street, and then Wyoming. This happened in Wyoming by Grand Rapids. It was deemed a distraction to drivers on 28th Street, and they had to restrict how much advertising they have right up on that street for traffic purposes. All right, so there's a lot more to commercial advertising and laws than what this book talks about. A relatively recent dimension of free speech relates to the efforts of both the national and state governments to limit the role of money in political campaigns. The Federal Election Campaign Act of 1971 included limits on campaign contributions to candidates for the presidency and Congress, disclosure and reporting requirements, and public financing of presidential elections. This one, I think we've already done this case. You should remember it. In Buckley v. Vallejo, the court upheld these provisions. However, it also included that spending money to influence elections is a form of constitutionally protected speech. Thus, the court voided those parts of the law that limited total campaign expenditures, independent expenditures by individuals and groups, and expenditures by candidates from their personal or family funds. That's the part you read already, that you can finance your own campaign. You can't limit someone's spending on their own campaign. It's freedom of speech. In 2002, Congress passed the Bipartisan Campaign Reform Act, often referred to as the McCain-Feingold Act. It banned unrestricted donations made directly to political parties, often by corporations, unions, or wealthy individuals, and the solicitation of those donations by elected officials. It also limited advertising that unions, corporations, and nonprofit organizations could engage in up to 60 days prior to an election, and it restricted political parties' use of their funds for advertising on behalf of candidates in the form of issue ads or coordinated expenditures. Now, the court upheld most of the law in 2003, but in 2007, it held that issue ads that do not urge the support or defeat of a candidate may not be banned in the months preceding a primary or general election. I wouldn't even be surprised if they go farther. There are countries that have freedom of speech, but limit campaign time and are very restrictive on campaigning than the U.S. The U.S. is almost constant campaigning for the presidency or the Senate, maybe even other positions. But remember, if you watch a commercial and it says, please call so-and-so and tell him you support, or please call her and tell her that, she should, that's an ad they're talking about here. It's not actually supporting or to support or to defeat the candidate, but it's implying it. Okay. In Citizens United, which is another case you've already covered, the court made a broader decision striking down provisions in McCain-Feingold and holding that the First Amendment prohibits government from restricting political broadcasts in candidate elections when those broadcasts are funded by corporations or unions. And it's usually mostly corporations, or if you remember, it's not a corporation necessarily like a business like McDonald's or Coca-Cola. It's a corporation that you create in order to funnel money in, because corporations are people, they're filings, they're not actually literally people, but they are independent entities, And so you can create a corporation on paper. So most of that money that's being spent because of citizens, I'm jogging your brain from last semester, most of that money that's being spent is being spent by like shell corporations, for lack of a better word, corporations that are only exist on paper. So don't be thinking of corporations here again as, you know, ExxonMobil or Chick-fil-A or whatever. Further limiting the reach of campaign finance laws in 2014, the court struck down as violating the First Amendment the overall limits that an individual can contribute to all federal candidates and the limit that an individual can contribute to political party committees every 2 years. Arizona created a public financing system for state candidates and provided them matching funds if a privately financed candidate's expenditures, combined with the expenditures of independent groups made in support of or opposition to that candidate, exceeded the publicly financed candidate's initial state allotment. The court held that the law violated First Amendment rights of candidates who raise private money because they may be reluctant to spend money to speak if they know that it will give rise to counter speech paid for by the government. Bottom line, speech often requires money. It costs money to speak politically. First Amendment protects political speech. Okay, because all these little specifics, I'm not testing you on, and I don't really think you should be expected to know. You do need to know Citizens United, though. You learned that last semester. Okay, moving on to freedom of assembly. Now, they say the last of the great rights, but they don't bring up petition, the right to petition the government. There are 5 in the First Amendment: religion, speech, press, petition, and assembly. And petition means your right to seek out or complain to the government. Freedom of speech is complaining about the government. Freedom of petition is complaining to the government. Okay. Commentators often neglect this freedom, the peacefully assemble, in favor of the more trumpeted freedoms of speech, press, and religion, yet it is the basis for forming interest groups, political parties, and professional associations, as well as for picketing and protesting. There are 2 facets to the freedom of assembly. So again, if you're part of an interest group, remember that from last semester, you're assembling, and that's protected. The first facet is the literal right to assemble, that is, to gather together in order to make a statement. This freedom can conflict with other societal values when it disrupts public order, traffic flow, peace and quiet, or bystanders' freedoms to go about their business without interference. Within reasonable limits, called time, place, and manner restrictions, freedom of assembly includes the right to parade, picket, and protest. Whatever a group's cause, it has the right to demonstrate. There's restrictions on them in many places, like where you can, like that's what they mean by time, place, manner, but you have a right. For example, in 2011, the Supreme Court upheld the right of the congregation of a small church to picket military funerals to communicate its belief that God hates the United States for its tolerance of homosexuality, particularly in American military. They would go outside of funerals. They didn't go into the funerals. They would stand where the government allowed them to stand, where the police officers said they could stand, and do their protest. And the Supreme Court ruled that that was protected speech. However, no group can simply hold a spontaneous demonstration anytime, anywhere, and any way it chooses. Usually, a group must apply to the local city government for a permit and post a bond of a few $100s as a sort of security deposit. And the courts might rule that that's legal, but that doesn't mean everybody agrees that's a fair or right interpretation. But it is what it is at this moment. The governing body must grant a permit as long as the group pledges to hold its demonstration at a time and in a place that allows the police to prevent major disruptions. There are virtually no limitations on the content of a group's message. One important case when arose when the American Nazi Party applied to march in the streets of Skokie, Illinois, a Chicago suburb with a sizable Jewish population, including many survivors of Hitler's death camps. In, quote, the case of the Nazis' march in Skokie, which follows below, you can compare your judgment on the case with the decision reached by the court. Protest that verges on harassment tests the balance between freedom and order. Pro-life advocates, or anti-legal abortion, if you want to say that way, protest abortion outside abortion clinics and seek to shame or even harass clients into staying away. Thus, rights are in a conflict. A woman has the right to obtain an abortion, or actually Roe v. Wade would be more like she has the right to have a relationship with her doctor. The demonstrators have the right to protest the very existence of the clinic. The courts have acted to restrain these demonstrators, setting limits on how close they may come to clinics and upholding clinic clients' damage claims. And Congress has enacted broad penalties against abortion protesters. I didn't actually know that. I'd be curious. I might need to look that one up. In 2014, however, the Supreme Court ruled that a buffer zone around a Massachusetts clinic restricted access to public space and was not narrowly tailored to balance rights. That's a common theme. You see that when the government makes a law, it has to be the least restrictive possible on people's rights. Pro-life demonstrators in a Milwaukee, Wisconsin suburb paraded outside the home of a physician who performed abortions. The town board forbade future picketing in residential neighborhoods. The court agreed that the right to residential privacy is a legitimate local concern and upheld the ordinance. This issue has been showing up both by liberals and the right and the left, both sides, where people are showing up to protest in individual homes. I'm not sure what the laws are. Maybe some local communities need to step up with laws like they're suggesting here. Anyway, right to associate. This is the second facet to freedom of assembly, is the right to associate with people who share a common interest, usually talking political, including an interest in political change. In a famous case at the height of the civil rights movement, Alabama tried to harass the state chapter of the NAACP by requiring it to turn over its membership list. In NAACP v. Alabama, 1958, the court found this demand as unconstitutional restriction on freedom of association. In 2006, some law schools argued that a law that required them to grant military recruiters access to their students violated the school's freedom of speech and association. Siding with the government, the court concluded that the law regulated conduct, not speech. In addition, it argued, nothing about recruiting suggests that law schools must agree with any speech by recruiters, and nothing in the law restricts what law schools may say about the military's policies. Nor does the law force law schools to accept students and faculty it does not desire. And student and faculty are free to voice their disapproval of the military's message. So they have to allow the military to come in to try to recruit, but they don't have to like it. Okay, so the next part we'll have is right to bear arms. Actually, I'm going to finish it up right with that. Okay, few issues generate as much controversy as gun control. I don't know if that's true, but okay. In an attempt to control gun violence, many communities have passed restrictions on owning and carrying handguns. National, state, and local laws have also mandated background checks for gun buyers and limited the sale of certain types of weapons altogether. Yet other laws have required that guns be stored so as to prevent their being stolen or used by children. Some groups, most notably the National NRA, have invested millions of dollars to fight almost all gun control efforts, arguing that they violate the Second Amendment's guarantee of a right to bear arms. Many advocates of gun control argue that the Second Amendment applies only to the right of states to create militias. Take a look at the commas. If you read the Second Amendment with commas, you can actually read it two different ways. Surprisingly, the court has rarely dealt with gun control. So there's only two issues that have actually been, or two cases and it's been incorporated to the states, and it's very limited now. So you cannot say you have a Second Amendment right to everything yet. That doesn't mean that's not a goal. But this, just like speech and press, it's limited. You get more specifics. Anyway, okay, so in 2008, however, the court directly faced the issue. DC law restricted most residents from owning handguns. The law also required that when not in use, all lawfully owned firearms, including rifles and shotguns, be unloaded and disassembled or bound by a trigger lock or similar device. In DC v. Heller, the court held that the Second Amendment protects an individual right to possess a firearm, that the right is unconnected with service in a militia, and that an individual may use a firearm for lawful purposes, such as self-defense within the home. So in 2008 was the first time that the court made a ruling on what the Second Amendment meant, and it meant personal ownership, not militia. Okay, now we got the next one. Similarly, the requirement that any lawful firearm be disassembled or bound by a trigger lock when not in use is unconstitutional because it makes it impossible for citizens to use arms for self-defense. Okay, next case, 2010, Donald v. Chicago, the court extended the Second Amendment limits on restricting individual rights to bear arms to state and local gun control laws. So that they incorporated it. They incorporated the Second Amendment to state law. But it didn't really go, it says you have a personal right to ownership. Got it? Nevertheless, like most rights, the right to bear arms is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, prohibitions on concealed weapons are permissible, as are limits on the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, laws imposing conditions and qualifications on the commercial sale of arms, and laws restricting dangerous and unusual weapons that are not typically used for self-defense or recreation. The reason that is the case is the court has not ruled otherwise. It's not that the court has ruled that these are okay. It's that they've been silent about it. And as long as they're silent about it, laws can be made on the regulation of firearms. So there might be a judge or two who do want to say that this is all unconstitutional, but to this moment in time, as I say this, that has not happened. Okay, so the Second Amendment, all that has been ruled by the court is a personal right to, I think it's just a handgun, shotgun. It doesn't even say like anything for self-defense, for protection. Okay, I'm going to end it there.